Welcome, friends, to this last part, AEFC 16. Argue in English fluently and confidently. Part 16. In this part, I will give the test of review petition and curative petition. I will show you the draft. And when review petition, we can file in Supreme Court against the order of SLP or any statutory appeal when dismissed from Supreme Court. When the result is not in our favor, that time we can file review petition. And after review failure, then we can find curative petition. So I will give the board test to you in this last part. So till this part, we have seen so many matters in different angles. Multi-dimensional practice when you have, then you will get the enjoyment of the legal practice in apex court. Till High Court, you can do specialization, but there is no chance for specialization in Supreme Court. You have to be a very all-round person. So, friends, we'll start before going on our main subject, review and curative petition. As usual, first tenses. So, just go in that PDF file, 1000 verbs, legal verbs, select any 10 legal verbs and practice that 12 tenses. 3 main tense multiplied by 4 subtense, total 12 tenses. It requires 35-40 minutes. Then, for finding out actual real vocabulary of the stalwarts legal luminaries, so I am giving you now, this is last partner, so I am giving you 3 speeches, beautiful 3 speeches. My hero, my ideal, Justice Rohinton Nariman's some speech and some speeches of CJI D.Y. Chandrachud. Though these 2 people have a different vocabulary and different memory level also. So I'm giving you 3 speeches. Just hold on, I'm sharing you. This is a federalism, federal government, state government, federalism, legislative relations between center and state. Justice J.S. Verma's second memorial lecture given by Justice Rohinton Nariman. So this is one lecture.
Verma, ladies and gentlemen, today's subject was close to Justice Verma's heart. In fact, we may begin by saying that our constitution didn't start on a tabula rasa. It did not adopt the strict Montesquieuan doctrine of separation of powers. That's because we adopted the Westminster style of government, where the executive does have a key role in framing and then passing legislation through parliament. But broadly speaking, we do follow what Hamilton said in the Federalist Papers, the famous 78, which is that broadly speaking, it's the legislature that makes laws and therefore holds the purse. The executive, which holds the sword, which has to execute laws made.
Link is given, friends, in one folder. You cut that link, copy that link from that folder, put in your YouTube browser and then play. Then you will get the HD quality video. You can enjoy it. Now, second lecture of D.Y. Chandrachud in Harvard University. after becoming CJI. He is the past student of this university, Harvard Law School.
Good afternoon, everyone. Thank you. Thank you very much, all, for being here on this lovely fall day in Cambridge, Massachusetts. We told the justice that we wanted him to remember what it was really like to be a student here, which we'll talk about, but that with that center, which that was
the face of the student. As a lawyer, I believe that my insights as a student at the law school helped me in terms of the litigation which I had a preference for. And I put their interface with law, the point of time, when they're not as cynical. And I think it's important that we tap the potential.
Listen 2 times, 3 times this video. This is very, very beautiful, very, very informative videos. And this is third video of CJI.
Hope and Justice expired on June 26. That is the day the emergency was declared. The legal community on many fronts, both inside and outside the courts, led the struggle to restore the rule of law. And Ram was at the forefront. He was the chairperson of the Bar Council of India during the emergency and was very vocal about his opposition to the emergency. In 1976, he spoke fervently against the imposition of the emergency.
In this lecture, you will get 2 things: the vocabulary of CJI and good information about legend Ram Jethmalani. In Ram Jethmalani's memorial lecture series in 2023, D.Y. Chandrachud has delivered this lecture. So these are 3 videos treasury I am giving you for finding out the word, difficult words like that. And as usual, practice pattern of this video. First, watch this video, enjoy. Then second, play, pause, find out difficult word, find out its meaning. Write each word with its meaning 5 times and use into your own sentences. Such type of hard work you have to take to develop your vocabulary. Then last part, review petition. Semi-last part, then last part, curative petition. So I will show you review petition. Generally, after getting dismissed case or after getting judgment, aggrieved party can move to Supreme Court in review petition. So review petition always go to same bench, because my judgment only I can review. So that bench judgment, so that bench can review. So that review petition will not go to another bench. So same judges will review it. But sometime, if one judge from that bench is get retired at the time of review hearing, that time another judge is there. Otherwise, before same judge, review petition is going. And review petition, as per Supreme Court Rules 2013, review petition you can file under section under Article 139 of the Constitution of India in Supreme Court, and within 30 days you have to file. Without 30 days, and if it get late, then condonation delay application we have to file. So I'm filing sometime review petition after 4 months, 5th month also, but filing separate application condonation delay, and many times it get the delay control. So this is the review petitions, little bit information. Now I am sharing you entire draft of review petition. See this review petition. File is getting open. Let me check whether it is shared or not. Yes, now it is shared. See the cost title properly. In the Supreme Court of India, inherent jurisdiction, review petition, number so and so in civil appeal number so and so, under Article 137 of the Constitution of India. So this is original case, original SLP or original civil appeal, which is not in favor of our petitioner. So review petition we are filing for this petition. So this is review. So we have to mention here review petition in civil appeal number. This is cost title. IA, two IAs are there. One IA is application for condonation of delay in filing review, because this fellow comes to me near about 2 to 3 months later, but I get delay condoned. And application for request for hearing of the review petition in open court. Many times they are not permitting the open court hearing. So in chamber they are deciding, but sometimes they are giving opportunity to argue in open court also. I will later, at the end, I will tell you exactly how review petition, if get review petition succeed, how it get the effective then. What is its effect on that matter, dismissed matter. So this is the review petition. Tender rules of tender, they have changed. All of a sudden, they have changed the rule of tender. Fisheries rule of tender. So this fellow gets aggrieved by the High Court order. Not by a High Court order. High Court's order is in his favor. In his favor, that High Court order is there. So respondent of High Court comes to Supreme Court in SLP, in civil appeal. That SLP get admitted, and now and he was a respondent. And at the time of when he was a respondent in that original civil appeal, that time he contacted me before coming to Supreme Court, before admitting that matter. So I already warned that person, Manoj Kumar Sahani, you filed caveat. I will try to dismiss it on first hearing. So High Court order will be confirmed, that which is in your favor. But he have not given proper focus. And hurriedly, and some bad things happens, and that matter not comes to me. So as a respondent, he give that matter to any other lawyer. But when it get dismissed, when the order, that is a reasonable order is there. I will show you that order also. But final order is not in his favor. So then he comes to me, sir, earlier I have missed your connection. But anyhow, you file my review petition. So I file this review petition. I will read some part so you can understand wording. That the instant review petition is filed under Article 137 of the Constitution of India against impugned judgment and final order dated 17/1/2023 passed by this court, Honorable Court, in civil appeal number 396 of 2023, by which this Honorable Court allowed the civil appeal filed by the respondent number 1 and quashed and set aside the judgment dated 25/3/2021 passed by the learned divisional bench of the Honorable High Court, and affirmed the judgment and the order dated 3/12/2019 passed by the learned single judge of the High Court. The respondent The respondent number 1 has filed the above civil appeal number 396 of 2023 arising out of the SLP number 5714 of 2021. So here you will get a little bit confusion. So I want to clear that confusion first. First, respondent come into Supreme Court in the form of SLP, special leave petition under Article 136. And when SLP gets successful, that SLP is converted into then civil appeal. So this is the same case, but SLP number is different, and when it get admitted in Supreme Court, then it convert into civil appeal. So civil appeal number is different then. So SLP number is 5714 of 2021, and civil appeal number is 396 of 2023. Against the judgment and final order dated 25/3/2021 passed by the divisional bench of the Honorable High Court of Guwahati High Court in writ appeal number 7 of 2020, whereby the divisional bench of the Honorable High Court passed detailed, well-reasoned judgment and was pleased to allow the appeal filed by the petitioner, wherein and set aside the learned single judge order dated 3/12/2019 passed in writ petition number 391 of 2019. So single bench order of High Court is not in our petitioner's favor, but double bench order is in our favor. So respondent comes into SLP, and SLP is not in favor of our petitioner, who is the respondent in Supreme Court. And now that respondent comes in review petition, so he is now petitioner in review petition. Case laws we have given here. This is the list of date. This is a review petition actual draft. Question of laws. Whether the impugned order bearing number CAN/PA 22/2018/285 dated 7/1/2019 issued by the respondent number 3, that is the Commissioner, North Assam Division, Tezpur, is valid in view of the Rule 13, 13C and 13D of the Assam Fishery Rule 1953 amended in 2005 and needs to be decided by the constitutional bench as it involves a substantial question of law. So read all these question of laws. Then grounds. We have to prepare full petition as a SLP. But we have to join SLP copy also to this petition while we're filing it. So annexure, everything is there. So see, such a huge X, Y, Z, then A ground, means near about 30-40 ground we drafted here. Here is my name, arguing counsel. Jayprakash Somani, and Sujit Kumar Mishra is by AOR. This is affidavit, which is mandatory here. This is the application praying for listing of the present review petition before 5 judges constitutional bench, like that. We have apply our mind here in different ways. So this is the draft of review petition. Friends, if review petition gets succeed, suppose that bench decide, yes, mistake is done, apparently, while I decide, while deciding this case, so review gets success. That time, that SLP get restored again, which is dismissed. That SLP get restored again, then hearing will go on. And so different result will come in that. But when review petition is not in our favor, that time petitioner can file curative petition. For review petition, time period is 30 days, which is given in Supreme Court Rules 2013. But for curative petition, no time limit is given in rules. In curative petition, only it is curative petition is depend upon the judgment of Rupa Hora versus Ashok Hora. Rupa Ashok Hora versus Ashok Hora. In this judgment, this review petition takes birth. Sorry, curative petition takes birth. Review petition is as per Article 137. Article 137 of Constitution of India. But curative petition is born through this judgment. So we have to mention that judgment. And in that judgment, Rupa Hora versus Ashok Hora in 2002, I think 2002 judgment. In that judgment, I will show you exactly year. In that judgment, they have given, after getting SLP dismissed and after getting review dismissed, curative petition can file when in rarest rare case to avoid the miscarriage of justice. But condition for curative petition is it should be filed as early as possible. No time limit is there. So you can file after 2 months, after 3 months, after 1 year also, after 5 years also. But as early as possible to get the justice. So this is my advice. After review petition, directly come to us or come to any lawyer, Supreme Court good lawyer, for filing curative petition. If you wish to take last chance of the justice, but even though you are coming late, we can get condonation. No alteration about that. And second thing, important thing, in this curative petition, senior designated lawyer certificate is essential. Senior designated lawyer certificate is essential. Without senior designated lawyer, and senior designated lawyer is certifying that in this matter, these points are important and this point I had not considered earlier. So, curative is must here. Curative should get accepted because this point has not heard earlier. So, such type of certificate when senior designated advocate is given, that time we can file curative petition. And curative petition goes before same bench, but 3 more judges is added. So earlier bench, suppose 2 judges bench is there, and 3 judges added of Supreme Court senior most 3 judges. So Chief Justice of India is senior most judge. So below that 2 senior most judges, they are added in curative petition, and they all judges are deciding the curative petition. So this is the way how curative matter is filed. I'm showing you Very fantastic curative petition. Very, very good. What is this petition? Surprise. Such type of case happen in Supreme Court. This is a surprise. Eager? Very eager to know, huh? Yes. I'm also eager to tell you. LIC employees, they win their case in labor court much earlier, say 15 years back. Then that matter come to High Court in appeal. High Court decision also in LIC employees' favor. Then that matter comes to Supreme Court. Supreme Court decision is also in favor of LIC employees in 2016. And that was a reported judgment. Respondent LIC filed review petition. Review petition get dismissed, means that decision goes in favor of LIC employees. Then respondent file curative petition. Curative petition get dismissed, means that is in favor of LIC employees. Even though as per the decision given in 2016, final appeal from Supreme Court, LIC has not reimbursed any compensation, any their pending salary, pending dues, whatever it may be in order. I will show you that. So LIC employees file contempt petition in Supreme Court. See, labor court decision in our favor. High Court decision is in our favor. Supreme Court decision is in our favor in reported judgment. Review petition is in our favor. Curative petition is in our favor. Even though LIC is not implementing that, then we file contempt petition. And contempt petition, in contempt petition hearing, bench of contempt petition evoke Article 142 and they give the order to rehear this case again. So these efforts of last 15 to 17 years get vanished. Many petitioners get died like that. So we file review petition against that order. Review get dismissed. Now we are filing curative petition against that order. This is a very bad thing. Very bad thing. But they can evoke article. But what is the wording of Article 142? 142 is such a power to Supreme Court. Only Supreme Court have that power. No other court have that power. I call this article as a Brahmastra of Supreme Court. They have the Brahmastra to give the complete justice. For giving complete justice, they can give any order under Article 142. So Ram Jalma Masjid matter is decided under Article 142. But for the complete justice, but in this case, for the complete injustice, if you are looking through the eyes of LIC employees, they got injustice by this order. But if you are looking through the eyes of LIC, they got justice. But I am from employee side. So this is great injustice. So we file curative petition. Now see the curative petition. And you read this curative petition. And under Article 142, we can file curative petition. If condition is fulfilled, which is given in that particular case of Rupa Hora versus Ashok Hora. I will show you. Just give me a few seconds. Curative petition. Yes, it is open now. See the cost title. See the cost title in the Supreme Court of India. Inherent jurisdiction, curative petition, in review petition, in miscellaneous application, arising out of the impugned and final order dated 15/3/2023 passed by this court, Honorable Court, review petition C, review petition civil number 499 of 2030 in the matter of All India National Life Insurance Employees Federation petitioner. M.R. Kumar, Chairman, Life Insurance Corporation of India, respondent. And in the matter of review petition. And then original miscellaneous application is also given with IA number. Manju Jetli is AOR in this. Manju Jetli is one of our panel AOR in my law firm. She is elder than me also. That the instant curative petition is filed under Article 142. Let me share it is a shared or not. Let me see. Let me check. Yes, it is shared. Okay, you can watch now. And is directed against the impugned final order dated 15/3/2023 passed by this Honorable Court in review petition civil number 499 of 2023, whereby this Honorable Court was pleased to dismiss the review petition filed by the petitioner and rejected the prayer for open court hearing also. The petitioner filed the above review petition to review the common impugned final judgment dated 27/4/2022 passed by this Honorable Court in miscellaneous application number, that is contempt petitioner, miscellaneous application number 1765 of 2019 in contempt petition C number 1944 of 2017 in civil appeal number 6956 of 2009. After High Court order, they come into Supreme Court in 2009, may come into 2008 also. 2009, appeal heard, decision comes in 2016. See the time lapse. See the speed of justice delivery in our country. And Supreme Court given in our favor decision in 2016 reported judgment. And when battle started, I will show you that also. Original battle started. After getting success in all court, including Supreme Court, after Supreme Court order, review is in our favor, curative is in our favor, and then all of a sudden in contempt petition, they are denying all these things. Surprising. But they evoke Article 142. Sometimes I am getting very sad because of this judicial system, friends. But what can we do? We have to fight only for our client. This case was not with me earlier. This was with me from review petition. Review, and then we filed this curative petition after contempt petition. A contempt petition, if I was involved in contempt petition, then definitely I will not let matter here and there. No. But unfortunately, after contempt reverse result, this matter comes to me. But we trying at our best. Now, curative petition is pending. See here, it is stated that there is a very unfair and misuse of Article 142. Instead of initiating contempt petitions against the respondent LIC and giving justice to thousands of LIC workmen, this honorable court has restarted a process of inquiry. The petitioner employees fought this battle since 1991, and they own in labor court, appellate court, and finally this honorable court has given justice in SLP civil appeal in favor of petitioner employees white judgment dated 18/3/2015. Then the respondents filed review and curative of the common judgment dated 18/3/2015. 2015-9 SCC 62 is the reported judgment citation price before this honorable court. Both the review and curative petitions were duly considered and dismissed by this honorable court respectively. Then finally, the petitioner employees won this long battle. So they filed contempt petition before this honorable court. Unfortunately, this honorable court's three judge bench overruled all this decision, including even the five-judge bench of this court. This unfortunate surprise happens first time in the history of the apex court. This is a severe injustice and misuses of, but these are my wording, friends, in drafting. I'm getting tears in my eyes. This is a severe injustice and misuse of Article 142 has been done by this three-judge bench of this honorable court. This is a huge black dot on the reputation of this honorable court. As noted above, the impugn order suffer from serious apparent error in the law warranting interfere by this honorable court. Humble petitioner is begging for this justice. Hence, the instant curative petition is filed. Following are the most significant point to allow this curative petition. One, that is the Article 142 inherent power is only applicable when there is no specific statutory law. Inherent power should be applied in the rarest of rare matter. In the ordinary course of affairs, it cannot be applied. However, at the best, it could have been utilized for fixing, determining the cutoff date as per the section 18(3)(d) of Industrial Dispute Act 1947, because of the entire proceeding is silent on cutoff date. That in the contempt matter here in the honorable justice have instead of getting the appliance of the orders of the honorable apex court of the country, the sitting judges have reopened the subject matter involved by hearing ab initio and thereby set aside the already reported judgments in AIR, etc. for the reason best known to them, which your wisdom will to appreciate, directly creating bad impact, damaging the reputation, dignity, etc. of this honorable apex court of the country and judicial function in general, causing grave injury to all concerned, beside losing faith in the apex judiciary, etc. of the country. That that various learned advocates also raise the issue in the matter from time to time. Very recently, the Honorable Attorney General Sri K.K. Venugopal again took up the issue in the matter, stating that certain judgments have gone away, ridden over the judicial boundary, spare of the lawful demand and the requisites, and such have created the otherwise effect in mass and general. So read all points, friends. Read all points. After this winter vacation, I will mention this case before Chief Justice. And what is bad? Chief Justice, who is my hero, who is the hero of all lawyers in India, D.Y. Chandrachud. He was in the contempt petition. Now he is Chief Justice. But I have to argue opposite to Chief Justice. Just opposite. He have greeted me. He have given me award because of my publication books. And really his vocabulary, everything I have shared so many of his video. He is learned person. But even those in some cases I have to act against our hero also. That is the education given in Bhagavad Gita also. For justice, you have to fight against your relatives also. I'm speechless, friends, speechless. You take the printout of this thing and go see their battle started. In 1991, Labor Court have given decision, but matter started in Labor Court and matter dispute started from 1982. See, friends, 1982, Labor Court given order in 91 in our favor. After that, High Court given our favor. Supreme Court given in our favor in order in 2016. See the delay of justice delivery system of our country, friends. Where to share this pen? Not this happens to every case, but in some cases, such type of huge negligence is there. And after that also, when rehearing started of that case, what is the bad? Now 2023. Dispute started in 1982. Step by step list of date you can observe. Case laws, we have added some fantastic case laws. This is beautiful draft, different draft. This is the original petition, curative petition. Grounds, question of laws, grounds. Too many grounds we have added, friends. This is certificate of error. This is affidavit of petitioner. And this is application for oral hearing. And this is certificate of senior advocate. Here he writes, in this certificate he writes, the curative petition is also fulfill the requirement as per the guidelines laid down in the judgment, that is Rupa Ashok Hura versus Ashok Hura and others, reported in 2002 for SCC 388. And we added a point also in this certificate. Nobody is preparing such type of beautiful certificate, which I have done. When I sent this certificate for senior designated lawyer to sign it, so he surprised, Mr. Somani, you have drafted very nicely the certificate. I have not drafted it. I have just given instructions to my juniors. Junior are drafting these matters, but as per my instructions, I am giving them dictation. I am giving them guidance. And petitioner also given us very nice information. Sri Vastav from Bihar, who is the leader of this employees federation. When he comes to Supreme Court, he comes to meet me. Now his age is above 80. Above 80. When he started battle in 1982, now 2023. And after getting success in all court, when there is not getting success and rehearing is happening, such type of foolish things are getting done sometimes, not always, but sometimes. But it hammers. It gives benefit to only LIC. It is injustice to all employees. Thanks. We should control our emotions. Otherwise, it is very hard to practice in apex code. But anyway, we have to control these emotions. Thank you very much for patiently hearing. This is the test of review petition and curative petition. Each and every day, each and every moment in my apex court, in my practice with my all 12, 13 juniors, AORs, and so many my colleagues all over India are also there. High Court lawyer who are using, High Court judges also who are using my books, more than 50 books, with the grace of Lord Krishna and with the grace of my Guru Nani Palkiwala, I am able to publish. All books are available on Amazon and Flipkart. Continue, endeavor to get the justice. This is the practice, friends. All the best. I wish you a great success in your life. You will be India's #1 lawyer in future. This is my best wishes. Just work hard. Do proper time management. Focus on the success of the client. Don't focus on earning money. Money automatically is coming. Maintain dignity of your court. Maintain dignity of your colleagues. Maintain dignity of your profession. Follow the rules of Bar Council of India. And in the frame of law, work. Within 5 minutes, when you are on bed, within 5 minutes, you get sleep. Yes, I'm getting that regularly. No need to take any 1 peg, 2 peg for getting sleep. No. No any pills required for me to get the peaceful sleep. Whenever I put my body on bed, within 5 minutes, Lord Krishna is giving me peaceful sleep. This is the grace of my Lord Krishna. He is always with me. Before this body also, in earlier bodies also, he was with me. In this body also, he is with me. In next bodies also, he is with me. This is the training of our soul. Different births are the training of our souls. Thank you. Thank you very much. Enjoy. Share your feedback. And if you like this course, share to other lawyers also. Thank you. Thank you very much.